Good afternoon, everyone. I am Dr. Emma Perro. I am a lecturer at the Faculty of Law, University of the West Indies, St. Augustine campus, and I'm very pleased to welcome you to our fifth Research Skills Series session today. So we're continuing on from semester one. We're now in semester two of the academic year 2022-2023. Today, we're going to be speaking about the role of law in policy making. And we have Carlon Mendoza here with us. Carlon's going to introduce himself. Unfortunately, our other speaker, Cavell, is experiencing a family issue, so she can't be with us here today, so we will reschedule her talk. But I'm sure Carlon has a lot of interesting things to tell us. So Carlon, I'm going to hand over for you so you can tell us about your background, and then let's enter into this discussion.
Hi, good afternoon, everyone. Thank you for having me, Dr. Perro, on this research seminar series. So, my name is Carlon Mendoza. I am currently a climate policy advisor with Climate Analytics, Caribbean. So we have a Caribbean office that was recently opened last year, but the major climate analytics office is headquartered in Berlin. And we have several other regional offices in Asia, Africa, and the Americas, New York particularly. So my role or my purpose today is to just keep it light and give it a very introductory, have a very conversational approach to this discussion on the role of law in policy and in policy making. So to get started into this discussion, we first need to differentiate what we understand between policy and law. So the policies are usually documents or guidelines that outline what a particular ministry hopes to achieve. And that is the methods by which they hope to achieve a certain goal and the principles that they will use to achieve that particular goal. It kind of gives a big broad overview or picture of the objectives or the goals of that ministry. So the policy is usually found in a document format, PDF, Word, anything that is published and easily distributed, whether it be via the ministry's website or whether it is handed physically in a document. But it will often identify what is the objective, and sometimes it goes further to identify what laws are needed to ensure that these objectives are met and ensure that these goals are achieved. So now we can see that the distinction there is in law, where law is a set of standards, procedures, principles that must be followed. Law usually takes the format of mandatory legislation. It usually takes the format of regulations. And if a person does not follow the prescribed law, does not adhere to the law, then there are penalties that would be applicable for such breaches or such disregard. So we could automatically already see that the policy document does not hold the entity, which would be the ministry or the government in this instance, or any organization, because an organization can have a policy document. It doesn't hold that organization. It doesn't give a hard and fast rule of that these are the objectives to be met, these are the goals to be met, and then if you do not or you fail to meet those goals, then there's a penalty. So what we can simply see from the difference there is that policies set out goals and the laws, the policies may include certain laws or certain guidelines to prescribe laws in the future. And then that's where the government will now, or the executive will now be guided by these laws in the furtherance of their responsibilities. So we have that overview of this topic, law and policy. So what I'm going to do now is kind of like take you back into my, I guess, professional path as to how now we see the actual working of law and policy. So how I became involved in policy. I think first of all, let me start from the premise that I did not intend or did not see my legal career taking this format 10 years later. I always envisioned being either a prosecutor or being in court, and I had my fair time in litigation as well. But I recently had, well, not recently, I would say in the last 4 years, there was a switch from that type of advocacy into this more policy-based advocacy. So I'm currently a climate advisor or climate policy advisor in climate analytics. What that simply means is that there is the international process of the UNFCCC, United Nations Framework on Climate Change. And in that international process, you have international agreements, what we call treaties, that countries are parties to. And that would be particularly the United Nations Convention on Climate Change, and then the Paris Agreement of 2015, and the Kyoto Protocol. So I won't go into the legal, all the legal documents, but those are what guide the functioning of the climate law and climate change space when it comes to the international commitments by party members or countries who are parties to these treaties. And that process requires you to, one, know the area that you're dealing with, which will be climate change, which will be the varying thematic areas on climate change, which are like, for example, adaptation, mitigation, loss and damage, the global stocktake, just transition, just to name a few. But you will know those thematic areas, or you'll be involved with the subject matter of those thematic areas, and then you would go through a process of negotiating different outcomes based upon these conventions. So the conventions set exactly what is to be achieved, but then you have to now establish how parties are going to achieve it. So then now you clearly see in the link that I made earlier with respect to policy. The policy now kind of sets out how you're going to achieve it. So that is where, so in that setting, you have technocrats from all variants. So not only lawyers, you have specialists who are adaptation specialists, climate scientists, researchers, etc., who all meet to discuss the ways to achieve these goals. And those will take the forms of decisions. And when it takes that form of a decision that will be enacted at the end of a conference, which is usually called the Conference of the Parties, COP, that would now dictate what are the next steps, whether it's a plan, it's a program, whether there is finance. So you might have heard about the loss and damage funding facility or mechanism that was established in COP27 in Egypt. So in that instance, you would hear about all the procedures or processes to get the goals achieved, which the goal of the overall Paris Agreement is 1.5 degrees to reach, not to exceed, 1.5 degrees. So with that, now we're going to look at how the transferable skills of law, or being a lawyer, or being a law student or practitioner, can come into play. So in this one, it's simply advocacy, negotiation. You advocate for a certain change, you have to be able to articulate your point, you have to be able to express exactly what it is you want to see change. In legal methods, a formula that I still use up to today in any form of writing, for first year law students will know the FILA. I think it has a number of variations, but the facts issues law application or analysis formula that you use to outline your thoughts or present your arguments or your ideas. That is exactly the same format that I utilize in presentation or in researching, in giving an opinion, anything in this climate space or in this climate policy space. Your research skills in terms of knowing where to look, how to cite, how to make sure that you are not plagiarizing anything, it is transferable as well. And then finally, your drafting skills in terms of being able to be concise and articulate your point well in writing. So we can talk about, I already kind of went into the kind of examples from the UNFCCC process. So when we have that sort of document or decision that comes out of it, that document still stays in the international space. And not to delve into international law too much, or public international law too much, we all know that in terms of, even though you're a signatory or party to a treaty, that agreement does not necessarily have full effect in our domestic courts. However, in this space, where we see now that interlink, or that connection, is when those decisions are formulated, those decisions actually become part of our national policies. So one of the major national policies that we have under this process is called the NDC, your Nationally Determined Contributions. It is a document that is supposed to be prepared by each country or each party that indicates all the major steps that they are taking to mitigate climate change, adapt to climate change, and deal with a just transition. So that is where those decisions that are taken at the international level are now translated to the domestic level through policy documents. So the NDC is one of the major policy documents in this arena. You also have a national adaptation plan, which again indicates what are your adaptation strategies, what are the plans or procedures in place to deal with climate change adaptation. What is in place for the agricultural workers? What is in place for farmers? What is in place for persons in the energy industrial sector? What is just generally in place for the populace in terms of how we adapt to climate change? And furthermore, we have the national environmental policies. And Trinidad and Tobago has a national environmental policy that goes into detail about certain aspects of climate change and the same areas that I had just referred to. So now those policies can, going back to the original discussion, those policies can now be translated into law. So I can give you a very concrete example. So some of the work that I currently do, even as policy advisor, still goes back to legal work. So currently we had a project with the St. Lucian government where we redrafted their climate change bill or act. And that was heavily based on their policy documents, their national determined contribution document, their national adaptation plans, and the environmental plans. And a team and I, we sat and we literally looked at their legislation in terms of the environmental legislation and looked at all different pieces of legislation that was linked to this climate change bill. We looked at where St. Lucia was in terms of their position in the international scene with respect to their mitigation and adaptation strategies, how advanced they were, and also now looking at how fertile was the area in terms of, is St. Lucia ready to deal with certain other aspects of climate change? For example, with respect to funding and financing, or with respect to commitments in terms of reporting and carbon captures, and lots of scientific definitions that when you get into it, you have to know, but you're not expected to know as an attorney, but you have to be able to convey and understand the ground or the framework that you're operating in and legislate according to that framework. So we know you can't legislate something that somebody is not prepared to handle or deal with. So within our consultation process, we had to ask the questions or really delve into the meat of the matter, whether the government, one, was committed to these positions, and two, whether the government was committed, and two, whether it is the right time to actually place St. Lucia in this position to give these commitments under domestic legislation. Because now you understand that we're moving from a policy document that they already had to climate change law, which now, if the government or parties or whoever does not adhere to this, we go back to it. If they don't adhere to this, then there are penalties for breaching the acts or the provisions of the act. So with respect to, that aspect of that translation, that is where we see the rule of law and policy colliding. And we see that it is something whereby students or persons who are practitioners or lawyers or students or persons interested in this field can utilize their transferable skills that was garnered through the process of being an attorney or going to law school into this policy field and into the other areas. So what I would kind of conclude with, I know it's 15 minutes I've been speaking for, and I felt like I've been speaking a lot. But what I would conclude with is that I am giving you my example from the climate change, climate arena. And just as I'm giving this example, this can happen in any other arena. So you, for example, if you are a person interested in family policy or family law, we have avenues for that in Trinidad and Tobago in terms of policy documents. Every ministry, every particular ministry has policies that they adhere to, but then now it's utilizing those policies either to make law or ensuring that it is followed, it is adhered to, and that the understandings of it is given the highest regard. So I would hand over to Emma at this moment, and I hope you all enjoyed the brief talk. I know it's lunchtime, so it's a lunchtime series, and I hope that I haven't taken much of your lunchtime. So if you have any questions, I'm still on the call.
Thank you so much for that, Carlon. That was very interesting. And if anyone has questions, you can put them in the chat or you can raise your hand and unmute. But while people are thinking, so Carlon, I think you gave a really good explanation of the relationship between law and policy. And this is actually something I've been looking at recently, and I have a question for you, but I don't want to put you on the spot because obviously you're in a professional capacity as well, so you don't have to necessarily answer if it's not appropriate with your position or whatnot. But my background is intellectual property law. So I've been looking at the technology mechanism, technology framework under the Paris Convention. And from some of the research I've done, there's been a lot of hesitation to specifically include the words intellectual property or patents within the actual legislation relating to technology transfer. And based on what I've seen, it's because it's a stalemate between developed countries that want very strong IP protection, developing countries that want more access. And of course, keeping in mind that a lot of the technology is coming from developed countries. To achieve this just transition, the technology transfer needs to take place. The legislation itself speaks to technology transfer without directly speaking to intellectual property rights. Do you think, coming at it from the policy side of things, do you think that it's sufficient for the legislation to go about in this manner because there are correlating policies that will ensure that the intellectual property rights are accounted for? Or do you think in this case, perhaps the policy needs to inform the legislation more, although I know that's very complicated, to ensure more enforceable obligations?
Right. Excellent question. And I think I'll, as you rightly said, I'll keep it very professional in the capacity that we don't need to disclose too much information. But generically speaking, I can give an example of what the intellectual property rights or discussion what has been happening in that particular space, having been to Egypt and developing countries, because as a member of AOSIS, the Alliance of Small Island States and Developing States, Caribbean and Pacific, what is more important to us is the fact that sometimes it is seen as when that transfer happens, or sometimes the transfer or the technology is actually something that has been in practice in a developing country in terms of their cultural or indigenous practices before. And sometimes these countries always feel at a disadvantaged position because of the fact that the developed countries are coming in, and I'll be very careful to say this, it's a matter of not having ownership on our side of the table, the developing side of the table. So to get to your question quickly, it is a matter of a strategic matter of placing in policy at this beginning, because as already stated, that policy document is something that will kind of guide relationships, whether in country, whether in terms of a bilateral agreement between a developed and developing country, that you might be able to have more leeway or wiggle room to agree to certain intellectual property considerations within a policy document rather than legislation. So I will leave it right there for now with respect to that discussion, but it's something that has been touted around in the circles, and especially other communities that have these sort of rights much more prominent than you might be experiencing here in Trinidad, that we might be experiencing here in Trinidad and Tobago.
I appreciate that response. And I also think it's interesting that you bring up the fact of ownership, because that is something that always comes up in IP, particularly between developing and developed world, not just in this area, but things like traditional knowledge, traditional use of medicines, and the basically claiming ownership of something that was community owned or whatnot. So interesting to see how those themes translate. We have time for one more question if anyone has any questions. I know Carlon has a meeting this afternoon as well. So do we have any other questions?
I mean, if it wasn't that interesting, or you might be thinking later on, you can always email your questions to Dr. Pero, and I'll be sure to answer when she forwards me the email.
I have a question, sorry.
Yes, no problem.
Yeah, go ahead.
Okay, so I'm from the Faculty of Social Sciences, and my area of specialty is in migration. In the absence of a migrant policy / refugee policy, what is the role of law in policymaking for refugees and migrants in Trinidad and Tobago?
That's a very interesting question. The role of law in the absence of policy, and then it will go further into the absence of law, because we don't actually have a migrant refugee law. So my brief interaction with refugee law, migration law, we understand that there's the International Convention, UNHCR, all these acronyms, sometimes we get muddled, but there's a Refugee Convention, the 1951 Refugee Convention. And that convention is obviously, as I had indicated, similar in the sense of what is the role of international law. That convention, parties have signed on to that convention, and it deals with how we are to treat refugees. The criteria, the tests that will establish that someone is a refugee, the fact that a refugee or a person is not to be refoulement or refoulement, that word that they say, non-refoulement, in terms of you can't send back somebody without them having, once they come to the state and say that I am seeking asylum or refugee status. So that is the main thing, is international law. Recently, our courts in Trinidad and Tobago have actually dealt with these issues. Justice Voodoo Singh, I can't remember the names of these cases, but if you go and type migration, refugee law into the TT Law Court's website, you would see that we have had several cases dealing with different or varying issues or aspects of refugee law and migration and how we treated it. The law that is applicable in that instance is always the Immigration Act, because that is the act that we can stand on at the moment with respect to it, but the act does not refer to refugees and all these things. So it's a bit of a legal gymnastics that occurs with how you interpret certain things. Recently, again, I'm not a law lecturer, and this is just my pure memory of international law and the application. I know the CCJ court, even though it's not our highest court, has dealt with how we can interpret international obligations into our domestic fabric. I think the case is Nervy. I may be wrong. But that court also shows us how we can utilize that international law, what we have in domestic law, and what is the current state of play with respect to customary international law, what is happening around, and how we are to deal with refugees in that case. So in the absence of a policy, we use the Immigration Act in Trinidad and Tobago, but then we have to now fit or furnish international law with the Immigration Act, with customary international law principle to come up with the desired result. And I can simply say that from those decisions, majority of the decisions have been on the side of the refugees in terms of they have been successful in their claims from this court. So I would urge you to go and have a look at those decisions. I can't remember the names, but as I said, if you just type in migration, refugee into the search bar, even on Google, you would actually get some of the cases.
This is with the ICC?
This is with our High Court, our High Court. Trinidad and Tobago Supreme Court right here. Yes. Particularly am aware of Justice Buddha Singh when he was a High Court judge. He's now a Court of Appeal judge, but when he was a High Court judge, he dealt with a matter under this heading. Even Justice Sipasad has also dealt with matters under this topic. So there are a few judges who have dealt with, I should say about 5-6 cases out there with different areas of migration law and how we've dealt with it in Trinidad.
Thank you very much.
Thank you for that, Carlon. Definitely some legal gymnastics when it comes to migrants and refugees. And interesting because this probably is an area that's very ripe for policy making in the absence of any, even more so in the absence of an explicit law domestically to deal with this area. So Shelley-Ann, if this is the area you're interested in, this might be a very rich future in terms of rewarding, I should say, not, rich in terms of what you can achieve for social justice and whatnot.
Right now. Yeah.
Okay, so now you know about the relationship between law and policymaking and the fact that we're definitely in a position where we need both law and policymaking in this area.
To go hand in hand, correct.
Yep. Yeah. Okay, so thank you everyone for that. Thank you, Carlon, for a very insightful talk on the relationship between law and policymaking and for telling us how you got here, because it is one of our non-traditional career paths where you're still using your legal skills. Loved that you emphasize that the things you learned in law school are still relevant. It's always great when people come and say, oh yeah, what your lectures are telling you, you will use them in the long run. So I really appreciate that. So thank you for that. Thank you for everyone for attending. And if you have any questions you think about, you can email me and I will pass them on to Carlon. So thank you very much, everyone, and have an enjoyable lunchtime.
All right, thank you again. Have a good afternoon, everyone.
Thank you.
Bye.